Justice Bankim Roy, upheld the judgment of the High Court and held that he was entitled to no further protection. The leading judgment is that of Justice Jagannath Shetty. Justice Shetty notes that one of the contentions urged was that the Prevention of Corruption Act did not apply to judges. It was urged by Mr. Gopal Subramaniam, a brilliant advocate, that since there existed no master-servant relationship, the Prevention of Corruption Act was not applicable at all. Justice Shetty rightly found that judges do not expect any favor from the executive and certainly cannot be placed in what is called a master-servant relationship. However, he held that Section 6C of the then Prevention of Corruption Act could not be interpreted ejusdem generis, and that as long as a judge was a public servant, he fell within the ambit of Clause C. It must be borne in mind that the Santanam Committee also recommended an amendment to Section 21 of the Indian Penal Code to include every judge, including any person entrusted with adjudicatory functions in the course of enforcement of any law for the time being in force. Justice Shetty held that a judge of the superior judiciary was a public servant and that the Prevention of Corruption Act was intended to include judges. It was submitted by Justice Veeraswamy that any criminal prosecution must follow only after the process of impeachment was completed. It was contended that there was no power in the Constitution or under any other enactment to suspend the judge or to refuse to assign work to the judge pending his trial or conviction in the criminal court, and the judge can insist on his right to continue till his removal even after his conviction and sentence. This submission, in my view, being advanced on behalf of a former Chief Justice of Uncharted High Court, is extreme. It is a position claiming undiluted immunity. The Supreme Court rightly rejected this contention and held that we know of no law providing protection for judges from criminal prosecution. The judges are liable to be dealt with just the same way as any other person in respect of criminal offences. Considering that the power to prosecute lies with the executive, the Supreme Court rightly held that there must be a judicious use of that power. The records in Veeraswamy's case show that the then Chief Justice of India had expressly permitted the prosecution. The Supreme Court exercised its jurisdiction as an interstitial lawmaker and applied the existing law to protect the independence of the judiciary and said that the Chief Justice of India will have a final say whether it was a fit case for proceeding under the Prevention of Corruption Act. We must bear in mind the following words of Justice Shetty. We consider that the society's demand for honesty in a judge is exacting and absolute. The standards of judicial behavior, both on and off the bench, are normally extremely high. For a judge to deviate from such standards of honesty and impartiality is to betray the trust reposed in him. No excuse or legal relativity can condone such betrayal. From the standpoint of justice, the size of the bribe or the scope of corruption cannot be the scale for measuring the judge's dishonor. A single dishonest judge not only dishonors himself and disgraces his office, but jeopardizes the integrity of the entire judicial system. Justice Lalit Mohan Sharma, who concurred, held that for the purpose of judiciary being really effective, the purity of the administration of justice and the confidence of the people in the courts is equally essential. Justice Sharma was, however, of the view that the sanctioning authority must be Parliament. Justice Verma dissented. Justice Verma was of the view that the provisions in the Prevention of Corruption Act are not applicable. He also held that it is time that a clear provision be made within the constitutional scheme to provide for a machinery to deal with corrupt members of the superior judiciary, which itself is necessary for the preservation of the independence of judiciary. In my view, the judgment of Justice Verma, which is predicated on two considerations, that removal under the Constitution is the only remedy, and that Santanam Committee was not directly concerned with superior judiciary with respect, are incorrect. In my view, the majority opinion which provided that in the event the Chief Justice of India was satisfied that a case of corruption was made out and that prosecution could proceed was indeed a necessary safeguard to protect the independence of the judiciary. But lo and behold, is it possible that we can even conceive that members of the superior judiciary could be proceeded against for corruption? And we are talking about a judge who was appointed in that phase of 20 years from 1950 to 1970. In my view, notwithstanding the observations of the Santanam Committee and also the judgment in Veeraswamy's case, Chief Justices of India have not established adequate internal procedures for personal accountability. In some sense, the extreme impunity of a judge charged with corruption should indicate that candidates who were appointed had flaws in their character. Although Justice Veeraswamy was a brilliant judge who possessed charisma and deep and varied knowledge, yet his conduct, not being above reproach, should have alerted those involved in the appointments process that something was amiss. Why is it that at the time of appointments, judiciary is unable to predicate what would be the unfurling of judicial behavior in office? Why is it that the government did not plead or engage with the judiciary that judiciary must put its house in order? I am very sorry to say that the executive governments have played a dual tune. One, it attempted to first interfere with the independence of the judiciary, and latter, it decided that the best actor to undo the independence of the judiciary was the judiciary itself. As history shows, that only 2 Chief Justices took an extraordinary step, and not without criticism, of withdrawing work from judges who had prima facie conducted themselves improperly. I still remember that even if, when Justice Shobhashachi Mukherjee, the Chief Justice, in a special sitting after court hours, explained why he decided to work from Justice Ramaswamy. Similarly, Chief Justice Ashutosh Mukherjee was only the 2nd Chief Justice who withdrew work from 4 errant judges. These 2 Chief Justices had unquestionable moral fiber, but their actions must have caused them more pain than anyone else could imagine. But is the impeachment procedure the only procedure to enforce or to demand accountability? In my view, the judicial office, its character, its demands, the personal evolution of an incumbent judge are relevant to understand that the constitution makers did not treat it like any other office. The pressure of independence freedom from influence, impartiality, integrity, propriety, equal treatment, competence and diligence are not the principles which were evolved in the conference called the Bangalore Principles, but these are implicit principles in the office of a judge. That we needed to even make them explicit is itself a measure of our decay. But the formulation of Bangalore Principles has been adopted all the world over to determine the suitability for judicial appointments, and the question arises, how do appointing authorities, in particular the Chief Justices, forecast the likely future conduct of a person whom they recommend for appointment? The Bangalore Principles of Judicial Conduct are today the basis of the principles of conduct of the Supreme Court in the United Kingdom. As I said, they are implicit. The preamble to the Bangalore Principles said that they are also intended to assist the members of the executive and the legislature, the lawyers and the public in general, to better understand and support the judiciary. However, in my view, these principles have not been adequately disseminated amongst the judges and the lawyers. It is not the statement of principles which is important, but that improvisations have to be attempted to translate these principles into daily judicial life. I regret to say that judges claim to be an institution, but that institution must be visible and must be open to suggestions and criticisms. The conferences of Chief Justices and Chief Ministers, which is undertaken periodically, passes off as a platitudinous exercise. It is only fair to say that the inward psychological processes must be embarked upon without any delay. I have been unhappy for many years in observing that lack of history and lack of knowledge of traditions has impacted the superior judiciary. Obviously, since the High Court exercises a certain degree of overwhelming control over the subordinate judiciary, its main role model is the High Court. Under the guise of administration of the subordinate judiciary, utterly improper conduct has been reported about many inspecting judges. The High Court needs to shed its feudalistic attitude, and judges are not expected to seek any favors from the subordinate judiciary. The consequent demoralization of the subordinate judiciary has now led the executive to look at the subordinate judiciary with disdain, claim in the public that they lack domain expertise, and proceed to set up regulators and so-called tribunals, which are sadly poor substitutes, if not any substitutes, for courts of judication. It is indeed a sad day for India that the rule of law is viewed as an obstruction by the executive. Constitutional conformity, if insisted upon, will be viewed with a measure of unwelcomeness, and to subvert it, the idea of regulators, which consist of retired civil servants, and appellate tribunals, which may be headed by retired judges, are constituted, ousting the jurisdiction of the regular courts in the administration of justice. This is an unfortunate trend, and I submit that tribunalization of justice in this country is completely unwarranted and is a breach of the Constitution and must be undone, and undone with a certain measure of vigor. In my view, it is possible for lawyers and judges to learn any branch of law, because one of the enthralling aspects of the legal profession is the ability to learn and acquire skills in new domains and new forms of knowledge. I am also deeply concerned that the Constitutional Amendment Bill was not even preceded by any form of consultation. It is sad to say that the superior judiciary was unable to engage a dialogue even with the legal profession, and it showed a distinct lack of imagination. I am also not unmindful that even the judicial academies have not built upon the determination of criteria for self-assessment and, more importantly, how to remove obstacles to the self-growth of judges. In April 2013, some media reports indicated that the executive government was contemplating reforms. The law minister was expected to advise the cabinet about the Judicial Appointments Commission by the 22nd of April. On 15th April 2013, a group of eminent lawyers wrote a letter to the law minister asking for a copy of the bill so that it could be available to the members of the public and the bar. The draft bill was kept as a very major secret of the state. The new law minister, in a report of the 2nd of June 2013, appears to have said that government has an equal stake in the appointments of higher judiciary. The consultation of both is absolutely necessary. According to him, the government must have a say. These reported comments were somewhat surprising because the judgment of the Supreme Court in the Advocates of Court case has never precluded the government's suggesting outstanding names for consideration. Equal stake should not mean equal ownership over the power of appointments. Without data, without scientific studies, without publishing a white paper, the government was keen to push for legal and constitutional reforms. Till then, in almost all speeches of the executive, judiciary was reminded that it was guilty of an overreach. In fact, it is a matter of sadness that the Chief Justice of India was persuaded to embark on an exercise to find out how many district courts were housed in shabby and battered buildings. The data supplied to the Supreme Court prima facie discloses three things. A, executive apathy to the judiciary by withholding the purse. Second, the inability of the Chief Justice of the High Court to effectively protect and preserve the conditions of work of subordinate judiciary. And C, that the central government was aware and yet a mere spectator. I am sorry to say that the suggestion that there must be equal stakes in the say is completely unfounded. In my view, the expectation that the judiciary would undo its own independence has been strengthened